Well, thank you, Vivek, for moderating the session. It was an interesting conversation, as Carol mentioned. So welcome back, everyone, to today's presentation. Today's event is brought to you by AITP-LA. So I just want to take a moment to introduce and thank our board members who are providing exciting programs for you. We do have some members present here. You already heard from Vivek, and then Carol is here, and then we also have Jay Carvin, and then Roger here. We at AITP-LA are focused on providing informative events for our audience. So I'm going to just take like a few minutes to just talk about AITP-LA Los Angeles overview before we go into the actual session. Association of Information Technology Professionals. It's a nonprofit organization that provides leadership and professional development opportunities to IT professionals. Our mission is to keep members informed of cutting-edge trends and best practices in managing technology, as well as to provide strong networking opportunities. Our chapter membership provides many benefits, which includes it's a community of IT professionals, and it's also about technology, bringing experts in their field to share cutting-edge ideas. It's about people, bringing together people to foster innovation and build professional networks. We have regular meetings that help members stay up to date with the latest trends and best practices in managing technology. These meetings are a great opportunity to share ideas and encourage innovation while also providing excellent networking opportunities. If you're interested, you can go to our website and find out more, or you can also email us at info@aitpla.org. So just some logistics. When we start the actual presentations, we would request you to mute your audio so that we can hear all the speakers. And please put your questions in the chat. We will be monitoring the questions, and feel free to interact in the chat. This meeting is going to be recorded, and we are going to put this meeting on our website in next few days. So at this point, I'm going to invite Jay Carvin, who is our Director for Programs. And thank you, Jay, for coordinating and doing this session. So can you please introduce our speakers?
Yeah, absolutely. Right. So first one up today is Jordan Fischer. Jordan is a partner with the Constangy cyber team and brings substantial enterprise and leadership to the provision of compliance advisory services. With her extensive experience in the global intersection of law and technology, Jordan works to provide public and private sector clients with vital data privacy and cybersecurity counsel and business strategic advice. He advises on a variety of regulations, including but not limited to GDPR, CCPA, CPRA, FCRA, and DPPA. Additionally, she has experience with biometric data laws, global data breach standards, and federal and state unfair business practices acts and privacy frameworks. She represents clients in contractual negotiations pertaining to technology, data management security, and privacy, and she assists in the development of customized right-sized compliance programs to address numerous regulatory requirements and industry best practices. Jordan is a cybersecurity lecturer at the UC Berkeley and a law professor at the Thomas R. Klein School of Law. Her academic research investigates the convergence of law and technology, as well as the practical implications of regional data protection regulations in the context of the global economy. She is a globally recognized speaker on a wide range of technology and privacy law topics. In addition, she hosts the podcast Cybersecurity and Data Privacy, the New Frontier for the American Bar Association, which concentrates on data security, privacy, and related legal topics. Without further ado, Jordan, take it away.
Thank you so much. I'm laughing because it sounds like I speak an acronym when you hear all the different laws and regulations that I get to cover. But let me go ahead. Someone can give me a thumbs up if you can see the slides. Perfect. So very excited to be here tonight to talk about a topic that is very near and dear to my heart, which is privacy. It is an incredibly evolutionary time in privacy law. It seriously feels like you blink and the landscape changes so rapidly. And we're going to talk a little bit about sort of what that current landscape looks like, and then some ways to find commonalities. I always like to reiterate to everyone that yes, while there's new laws, there's new decisions, there's interpretations that are coming out on a regular basis, there is a lot of commonality. And there's a lot of these approaches that are built on some of the core foundational principles. And when you're a business looking at how to address privacy, it's really important to recognize sort of these core principles. So I will make these slides available afterwards. Not going to do my bio since Jay did such a wonderful job at that. But before we dive into actually talking about the laws, I always like to level set when I'm giving a talk, when we're talking about these terms, data security and data privacy, because these are really thrown out there, you know, almost willy-nilly by the media, by professionals, by all of us sitting here, right? We just talked about privacy. We never actually talked what is privacy? What do we mean by that concept? And so I always like to just sort of lay that foundation, because understanding what we mean when we say those terms, data security and data privacy, is going to help us to then understand the laws that are coming out to reflect those terms. So we're talking about data security. Oftentimes we're looking at protecting the data, protecting the infrastructure, and we're protecting it from unauthorized access, unauthorized use, from some exfiltration. It could be internal or external actors. It could be malicious actors. It could be non-malicious actors that we're looking to protect that data. And data security is needed to have data privacy in a lot of instances, but there's different goals attached to them. When we're looking at data privacy, we're looking at the data itself, and we're asking ourselves, why do we have it? Do we have a lawful basis to have this information? Are we allowed to share it? Are we allowed to even process it the way that we want to be processing it? So I could have the entire infrastructure set up around this information. I could have the access controls, the security can be there, I'm encrypting it, etc. But if I don't have a right to have that data, I have a data privacy issue, right? It's really driven by the data itself. And it's important to recognize this because when we're looking at the different laws that are at play, whether that's international, federal, or at the state level in the United States, it's important to recognize that there's different goals attached to these concepts of data security and data privacy. Yes, the laws tend to talk about both of them, although a lot of the newer laws that we're going to talk about tonight really focus on that concept of data privacy, but it's just really key to recognize these sort of two different laws and understand the goals that we have here. So stepping back, I only have 30 minutes and I could talk about privacy for hours upon hours. And so what I'm really going to try to do is give you a little bit of a survey of the world of privacy as I see it today, with a full caveat that it could change in a week because the legislators are coming back in. We're going to get new privacy laws, et cetera. And this is a constant conversation. But looking, I'm going to keep this mostly in the United States, although I'm certainly happy to take questions about the GDPR, et cetera. But as we sit here today, we do not have a generally applicable federal privacy law. We certainly have many attempts by Congress to pass a federal privacy law, as of yet not successful. We have sectorial specific, which I'll talk about on the next slide, which means they're specific to certain different industries. And what we have in lieu of a federal privacy law is what a lot of us are calling in the industry a patchwork of state privacy laws. And so we see a lot of states, California leading the charge in 2020 with the California Consumer Privacy Act, now amended to the California Privacy Rights Act, which I know Tim is going to talk about. But we have these states that are creating these more generally applicable privacy laws that require certain proactive measures as they, if you're collecting information on individuals located within that state. It's taking a very similar approach to how our data breach notification laws evolved. Right now, we do not, like a privacy law, we do not have a federal data breach notification law. What we have is 50 different state data breach notification laws. So privacy is sort of going the way that the data breach notification laws went, and we're getting these very state-specific laws. There is a lot of commonality. I want to emphasize that, right? There are nuanced differences. I don't want to imply that there's not sort of a rationale behind understanding each law, but there's a lot of commonality between all of these. The million-dollar question, are we going to get a federal privacy law? I wish I knew the answer. If I did, trust me, I would tell you all and I would share it. There's been a lot of attempts. I think we are closer than we were 5 or 10 years ago. But does that mean we're going to see it in the next 5 to 10 years? I don't know. There's going to need to be a lot of collaboration at the federal level to get there. There's a lot of different stakeholders, the consumer side, there is the corporate side. And so I think there is clearly a recognition that we are going to need something that's bold. What that's going to look like and when that's going to happen is unfortunately an unknown. So what that leaves us with is, as I mentioned, these sectorial specific laws at the federal level, which I'm going to talk about here briefly. And then the main sort of driver right now is at that state level. And that's where we're going to spend some of our time here tonight. So when we're looking at that federal level, we do have laws that are in play, and we do have some agencies that are enforcing them. The Gramm-Leach-Bliley Act, or GLIBA, this is what is dictating privacy around banking. This is why you get an annual privacy notice from your bank if you have an account with them, detailing sort of the information they're collecting and what they're doing with it. It's very light. I would say it's not necessarily what you see in the modern day of privacy, but it certainly exists and requires certain privacy protections be in place. We have HIPAA, which I think is one of the most commonly known laws across the public, although I think it's one of the most misunderstood laws because there is a belief that it protects all healthcare information, and that's not actually the case. It is protecting protected health information, which has a very specific legal term attached to it. But it is sort of a law that exists in the healthcare industry. It is federally enforced and does give certain privacy rights at that federal level. The Children's Online Privacy Protection Act, or COPPA, we've actually seen a lot of discussion about this in recent times, especially if you've seen companies like YouTube, Nickelodeon, Disney being held to they've been issued fines for their failure to address COPPA and adequately protect and collect children's online information. And a lot of these are enforced by the Federal Trade Commission. That's where we see a lot of movement at the federal level. The FTC is not a privacy regulator, but it has become this de facto federal privacy regulator because we don't have one. And so it has taken a very narrow mandate of unfair or deceptive trade practices and created this breadth of regulation, or not even regulation, decisions that have created sort of this ad hoc baseline of security and privacy at the federal level. But because they have such a narrow mandate, they're really not able to aggressively go after companies per se. And in fact, the FTC has repeatedly requested that Congress put in place some form of a privacy law that would give them more of an effective mandate to go after companies. So, but as we sit here today, the FTC sort of is that guiding principle at the federal level. That's where a lot of companies are looking for guidance on what does it mean to have reasonable security and privacy. They've had some pretty, newsworthy decisions that have helped to sort of continue to wake up executives to privacy at that federal level. There's additional federal privacy laws. There's FERPA, which is the Federal Education Privacy Act that's dealing with education data and privacy. There's some nuances here and there. There's a Driver's Privacy Protection Act, et cetera. But generally, we're looking at very narrow, tailored laws. They're not as robust as you see internationally, like the GDPR, where it's sort of generally mandating this privacy practice for all businesses across all industries. So in the lack of a federal privacy law and sort of more that industry specific, what we have is a ton of state privacy laws. And I say this both jokingly and in all seriousness, I felt like this spring, every time I woke up, I was seeing a new privacy law. And I live and breathe in this space. You would think I would be prepared for it, but it just felt like waves upon waves upon waves of privacy laws that were coming out of these state legislatures. And it felt like sometimes you couldn't even keep up. And so what I have here is I have 2 slides. I think this is really important to sort of get a snapshot of the space that we see here, right? So this is where we stand in 2023. So as we sit here today, 4 out of these 5 laws have gone into effect. Now there's nuances to that. We can talk through what those look like, et cetera. But we have California's updated CPRA, which went into effect January 1st of 2023. It was enforced as of July 1st of 2023. There's an asterisk on that because there's sort of this pending case right now on some of the enforcement provisions. We have the Virginia law that went into effect January 1st. We have Colorado and Connecticut, both went into effect July 1st. And we're going to end the year with Utah, right? So that's going to round out our 2023. They all generally have some form of a cure period. California got rid of that cure period. So what that means is that if you're notified of any failure to comply, you're going to have 30 or 60 days to come into compliance. And I hate to be the bearer of bad news, but 30 or 60 days to come into compliance is basically nothing, right? Because it takes a lot more than 30 or 60 days to get there. And then this is sort of a snapshot of where we currently stand on 2024 into 2026, right? So this is the picture of what we're looking at in the next 3 years of what we currently have in effect. This slide is going to change. We are going to see more laws that are going to be passed. In fact, Delaware is waiting for the governor's signature. That will go into effect, I believe, in 2025. Right, so we're already seeing some updates to this spreadsheet right here. Most of what we're looking at is starting July 1st of 2024. Then it kind of rolls from there across all of these different states. So what does this mean? This means that, we've got a lot of new privacy risks that are going on right now, right? Privacy is a executive level conversation. It is no longer a set it and forget it. It is no longer collect and hoard as much data as you possibly can, because there's real regulations that have real bite, and we have a lot of press around it. And press usually means we're going to have some state attorney general action. We're going to have, government entities looking at this. So when I'm looking at sort of that snapshot of what we're seeing the state privacy laws go, the key privacy risks I see are, increased activity from state attorney generals. Typically, these privacy laws are going to be enforced by the attorney generals, with the caveat that California now has the California Privacy Protection Agency, which is solely charged with enforcing the California law, although the AG does still have some capability to enforce it as well. The Federal Trade Commission has certainly upticked its own enforcement, which is sort of a similar trend we see under the attorney generals. We see increasing roles for data protection authorities. This is much more prevalent in the European Union. It's a more common thing in the EU to have sort of these standalone agencies that are solely dedicated to enforcing privacy. As I said, California is the outlier in the United States by having its own agency. Whether other states will follow that model is not clear, but we haven't seen it yet, which sort of alludes to we might not see it in other states. That might be a really, California nuance. And then finally, from my perspective, I have certainly seen more consumer questions, more consumers demanding answers around privacy and security of businesses. I don't think we're at the point yet where we're seeing consumers make a ton of choices around privacy and security per se, outside of sort of the actual security community, which is much more intact with it. But I think we're seeing just sort of this privacy conversation hitting the mainstream, which is going to make people question, start asking questions, and then submitting requests to have their data deleted, to have it removed, to know what information you have, where did you get that information, et cetera. I have some clients that see 5 or 6 requests in a year. I have some clients that see 30,000 in a month, right? So it's really running the gamut, but it's there. And I think that's a big trend that we're seeing that's increasing the risk, because if you don't address those requests, the first thing they do is they go to the attorney general. I've had this happen numerous times. The attorney general usually follows up. And as soon as an attorney general starts asking questions, that tends to be sort of this pathway to getting oversight, et cetera, as we go down there. And then the big risk, and for a lot of businesses, is what's going to make them stand up and sort of pay attention, the monetary fines and the potential for a private right of action. A private right of action is where a user could directly sue and hold a company accountable for their compliance. This tends to be sort of the sticking point for a lot of laws getting passed or not passed. Businesses don't like a private right of action. Plaintiffs bar, consumer-friendly organizations want a private right of action. There's more capability to hold businesses accountable. It creates the opportunity for class action lawsuits. Only California right now has this private right of action in the context of a generally applicable privacy law. I'm putting sort of the Illinois biometric and all of that sort of in a different category. But all of them do have monetary fines that can be issued. And these fines can add up rather quickly because it's usually per incident or per violation. And presumably every time you collect the information, let's say I'm going onto your website 20 times in a day, that each time could be considered a violation, right? So it's something to be aware of. They can add up rather quickly. So I think this is sort of how you can, really get executives to stand up, realize what's going on, and pay attention to sort of add up those number of clicks on your website, multiply by the fine amount, and all of a sudden you'll figure out your budget for security and privacy rather quickly to sort of mitigate this risk. So that's sort of what's going on very, very high level at a regulatory space. And like I said, I could talk for hours on this, sort of diving into each law, diving into the international side. The GDPR continues to dominate out of the EU across the international space. We see a number of countries aligning to what's going on under the EU. California itself sort of took some lead from the EU, et cetera. But with my remaining time, I just wanted to talk about key trends and sort of commonalities that we're seeing and sort of dive into a few that I think will be extremely relevant. They're questions I typically get around these laws. So I thought this could be useful. So what are we seeing across the board generally in these laws? The first is pretty much every law has a consumer right component to it. Typically, the right is knowing what information you have on that individual, the ability to, update or amend that information if it's incorrect, the ability to delete that information, although with exceptions, so it's not a blanket right to delete information. And then we have these sort of abilities to restrict the sale or sharing of information. That's sort of the California specific language, but we kind of see a little bit of that in some other state laws. We also see the sort of concept of data protection assessments across some of these laws, where you need to proactively assess the privacy risks when you're collecting or processing certain data. You need to document it, you need to maintain that documentation, et cetera. We also see consistently in the United States this concept of opt-out consent, and I'll talk a little bit about sort of opt-in versus opt-out. But as we sit here today, outside of certain sensitive personal information, children's personal information, we're generally still in sort of this opt-out consent regime, meaning that I can presume consent unless the user opts out of it. Additionally, pretty much across the board, these privacy laws are requiring more transparency to the end users, providing notices to the end users. California requires that you update the notice every 12 months. So that privacy policy that hasn't been touched since 2018, 2013 is not going to cut it under most of these laws. It's going to be an annual exercise, if not more regularly than annually, to address those privacy notices. And then finally, global opt-out mechanisms. And then for some folks, this is called a global privacy control. That's the other terminology that a lot of people have looked at. But basically, this browser level capability for users to opt out of the collection of their information through cookies, tracking technologies, pixels, et cetera. And it's going to be at that browser level. So I'm going to dive into a couple of these just to sort of, flesh out a little bit more what we're seeing across the laws. So one of the key things that we're seeing around these privacy laws is recognizing that there's a lot of data that's potentially collected about you online. And so there's this big push, whether it's within the law or within the rules that are sort of explaining the law or within the regulation, any decisions that we see, to provide more transparency to users around this sort of online data collection, and then two, to allow users to opt out of it. and we're looking at online data collection, we want to be thinking about sort of two forms. One is active data collection. So this is me filling in my information, says, yes, send me your newsletter, etc. Oftentimes that's not our top concern. We certainly want to make sure we're informing users what we're going to do with that. If we're saying we're collecting it for a newsletter, we should send them a newsletter. We shouldn't then sort of sell that data off to the highest bidder type of thing, right? So there are some restrictions. But I think where a lot of companies get into, potential trouble is in what I'm going to call passive data collection. And so this is the data collection. As soon as I come onto your website, you're dropping cookies, you're dropping pixels, you're tracking where I'm going on your website. You could be using technologies to actually watch where I click to improve, quote unquote, improve your services. You could be using things to try to track where I came from, where I'm going, right? Because all that's super, can be super valuable information depending on your industry and your business. That passive data collection where I, as the user, am not actively giving it to you per se, that's where I think a lot of the regulatory attention is on. And it's often looking not necessarily at first-party data collection, although you want to make sure that you're doing that in a compliant way. You want to make sure that you're informing users in your privacy policy, but it's looking a lot at third-party data collection. This is the Googles, the Meta Pixel, this is the Twitter, cookies, etc., because the user might not have great clarity that this third party is collecting their information. If I go on to your website, the fact that you might be collecting my data, it kind of inherently makes sense as a user. But the fact that Facebook might be tracking me and then sort of using that data to target me with advertising, that's not as inherently sort of clear to a user. So when we're looking at this space, we really want to be conducting these cookie and pixel audits to say, okay, what is on my website? What is on each page of my website? Are we in fact using this data, right? If you're going to collect it, you better use it and have value, because if not, you just have a liability sitting on your website. And then do we want to keep doing this, right? Is the risk that we have of collecting this information, potentially being declared as selling or sharing that data, is that risk, worth the value that we receive from it? So this is sort of when I'm talking to a marketing team, this is the process that we go through. What's active collection? What's passive collection? Are we getting value from that passive collection? And if we're going to have it on the website, you better be able to articulate some bottom line value, or we're just sitting on a liability. So that's this is an area that I think has a lot of regulatory attention right now, especially if you're in a regulated space like healthcare, right? You do not want that metapixel sitting on your healthcare website. In light of all the litigation that we're seeing here. So definitely an area to be paying attention to and sort of going over with your marketing teams, which tend to be sort of the teams that are driving that website data collection. Briefly talking about consent. So the United States is sort of directly opposite of the approach in Europe when it comes to consent. When we're looking at the GDPR, when we're looking at the European Union, they are squarely in what we call opt-in consent, which means that the default is I can't collect your data. And I can only collect your data if there's some form of an express, affirmative, or explicit consent. That is opt-in. The United States is currently, as we sit here, the majority of the time, the exact opposite, which means we are opt-out, which means that I can presume you are consenting to me collecting your information unless you tell me otherwise. You have to expressly tell me otherwise. This is sort of that cookie banner that pops up for a lot of folks. That's probably the best example we can give you of opt-in versus opt-out. Now, there are some nuanced areas, like I said, sensitive personal information, children's data, where we're going to require that opt-in. And you can most likely understand that opt-out is a more business-friendly approach. The reason being that we are all lazy and we are most likely going to go with whatever the default is. So if the default is I'm opted in unless I opt out, I'm just going to be opted in. If the default is I'm opted out unless I opt in, I'm going to be opted out, right? So for a lot of marketing folks and sort of the data-heavy folks in your business, they are going to like the opt-out much more than the opt-in. So it's something to be mindful of, especially if you're dealing with a business that crosses different borders. The US is somewhat becoming an outlier in the fact that it still continues to operate under that opt-out mechanism. And so you'll potentially need to either do different approaches in different regions or go with the more restrictive if you're not going to take different approaches, which is the opt-in currently that we see under the European Union. Really briefly, there's a number of different data subject rights that you see across a lot of these different laws. I mentioned a few of them already, but deleting your information, disclosing what information you have on the individual, access to that data, correcting that data, knowing what information is sold or shared. A lot of this is going to require you to have a very strong data map, inventory your data, classify your data, and really understand how did you get it, what are you doing with it, and then what do you do with it when you're done, right? Are you storing it forever because we're all data hoarders? Are you deleting it on a regular cadence? Are you truly deleting it, or do you think you're deleting it? These are all the things that you want to be asking yourself, because when a consumer makes a request, you need to be able to substantively respond to that request. Europe, it's 30 days. CCPA is 45 days to respond, but that's not much time if you haven't put in place the processes and procedures in order to address that. So this is pretty standard across all the privacy laws. So if you're not doing it today, the likelihood that at some point you're going to have to do it is pretty high. And it definitely can take a lot of time to lay a strong foundation to be able to address these requests. I want to talk just briefly about the universal opt-out or the global privacy control requirements before I sort of wrap up and turn it over to our next speaker. But these global privacy controls and the universal opt-outs are pretty much becoming standard across the US state privacy laws. California calls it the global privacy control. It sort of has led the charge in this a little bit. But really, this is at the browser level. And this is the ability of a consumer at the browser level to set a control that basically says you cannot collect my personal information for targeted advertising or for the sale of my personal data. And this requires that businesses have the capability to recognize when someone has configured that browser level control to opt out of the collection and processing of their data in this manner. It also requires that you be able to push that sort of opt out downstream to any third parties who also might be on your website. There is a really good website. I think it's called globalprivacycontrol.org. It has some pretty good sort of baseline coding for your team to be looking at, to be putting into your website, etc. Definitely would recommend checking it out. They have a GitHub repo where you can pull some additional specs and everything. But this is something that is going into effect, kind of rolling into effect over the next year or two. So you want to be starting now looking at it, because dev teams need time to understand the requirements, to build in that infrastructure, to be able to recognize it. So globalprivacycontrol.org is where I would send your teams to sort of start to get a sense of it, and then take a look at their GitHub repo. Finally, another sort of component within here is these data mapping, data inventories, and conducting these privacy risk assessments. If you've ever done a data mapping, it's one of the most frustrating experiences of your life. Most likely, people don't like being asked questions about their data, why they have it, what they're doing with it, but it's incredibly valuable, and it's going to drive what regulations apply to you, what partners you need to have contracts in place with, what vendors you need to have contracts in place with, or be conducting due diligence. It's an incredibly valuable exercise to go through. It's incredibly painful, but the value certainly is there when you get through it. And then additionally, like I mentioned, increasingly the laws are requiring these privacy risk assessments to be in place to help you identify what are the privacy risks, what are the threats I might have to this data, and then can I implement mitigation strategies? Do I need to collect that data? If I collect it, can I encrypt it? Are there things that I can do to sort of mitigate that privacy risk? So finally, I'll throw these slides up here. We always recommend building out a security and privacy program that really addresses not only the policies and procedures and the technology, but also the people. You can put every piece of technology in place. You can tell them everything you want to tell them. But if you don't create that culture of security and privacy, I think it's really hard in today's world to create a very effective approach to privacy across the entire organization. So a couple of sort of last tips from me. Know your data. This goes back to that data mapping. Make sure you have administrative, technical, and physical controls. It's pretty much standard across all of these regulations. Forward-facing disclosures and consent mechanisms. This is the fastest way for a regulator to determine whether or not you are even thinking about privacy, let alone actually fully complying with the law. Review your data subject right policies and procedures. And then finally, I didn't talk too much about incident planning, but in today's environment, they always say it's not if, it's when. And so making sure that you can respond really quickly, whether it's a privacy incident or a security incident, can be incredibly valuable. So like I said, I'll make sure I share these slides around so folks have that in the future. I know I talk fast, so I'll stick around for questions after Tim's done his presentation.
Thank you so much, Jordan. Appreciate all the insights that you shared there. We do have quite a few questions, I think, already in the chat that we can cover at the end. And guys, feel free to keep typing in questions as they come up, and we can have the speakers answer them at the very end during the Q&A. Let me share my screen real quick. I'd like to introduce, here we are. I'd like to introduce our next speaker. All right, we've got Timothy Toohey. He leads the cybersecurity practice of Greenberg Glusker. Tim's work focuses on assuring that his clients' proprietary, personal, customer, and employee information and other sensitive data is fully protected and serves its intended purposes. In 2022, Timothy was recognized in the Los Angeles Times Guide for Business of Law Visionaries for Cybersecurity. Tim is an intellectual property lawyer as well as a privacy and data security attorney, and works hand in hand with organizations, entrepreneurs, and high-profile individuals on matters of data strategy and security. On the cutting edge of data's role in all aspects of society, Tim also skillfully facilitates conversations to mediate between the needs of technologists and executives to maximize effective data usage to comply with national and international laws, regulations, and best practices. If necessary, Tim represents clients in litigation. Tim says, protecting the data and intellectual assets of a company is essential to protecting its brand. In a data-centric world, unauthorized access and dissemination of personal and proprietary data can be fatal to a business. Our job as privacy and data security lawyers is to help clients understand and manage these risks. Tim's counsel also extends to enterprises whose activity touches and crosses foreign borders. He has particular expertise regarding transborder transfers of personal data under the GDPR, including implementation of standard contractual clauses. He has worked in the areas of new media, advertising, brand protection, and entertainment. He is experienced in intellectual property litigation, such as trademark, copyright, and trade dress matters, as well as intellectual property licensing. He also has over 20 years experience in business and corporate litigation matters, including unfair competition, general commercial litigation, consumer and regulatory matters, and class action defense. All right, without further ado, take it away, Tim.
Thanks very much, Jay, and thanks, Jordan, for that wonderful overview. I'm going to be doing something somewhat radical for me, which is I'm not going to be having a PowerPoint today. And instead, I'm going to sort of chat more about some practical things that I've been seeing in the privacy area here in California. My firm, as background, it has a single office. It's one of the largest single offices of any law firm in Los Angeles, but we have a single office, not counting a few of us who occasionally work remotely. But we have a wide variety of clients, particularly in the entertainment, e-commerce areas, and we tend to represent more middle market businesses. So we don't do HIPAA work, for example, or Gramm-Leach Bliley, but we do deal with a lot of the day-to-day work that businesses are encountering in the privacy area. And Jordan gave an excellent overview of all that, but I'm going to be concentrating closer to home today. I'm going to be concentrating on the CCPA. And as Jordan said, there are some regulations on that have been put into abeyance by a court in Sacramento, but I'm going to pretend as if those are all actually still here in effect. Our California Consumer Privacy Act was passed in 2018 under very unusual circumstances, and it became and still remains the leading state's privacy act in the United States. It's a model for other states, and it was modified in 2020, the famous election of that year in November. It was modified by something called the CPRA, but the statute that is in effect is the CCPA. The CPRA was essentially a voter-mandated red line to the CCPA. And so many of you probably in California have heard a lot about the CCPA and realize that it is a comprehensive privacy law that deals with a very wide variety of personal information of California consumers. Now, it is true that not every business in the state of California is subject to the CCPA, or in the United States for that matter, that there are various criteria. There has to be $25 million in revenue, or 50,000 records, or a company that receives half of its revenues essentially through personal information. But I think that regardless of whether your company or your clients fall directly within the strict bounds of the CCPA, it is important to be aware of its provisions. And I'm going to concentrate on several practical aspects of what that means for businesses, particularly in the area of recruiting, employment, and contracting, because that's one of the biggest changes in the CCPA. And there will be several things that I'm going to refer to here that have practical importance to almost all business. One is the privacy policy that is either on a website or distributed to employees or otherwise available. The second are the terms of use of a website or terms of use of a particular product, because that is important in the raft of new lawsuits that we're seeing that are coming out. And I think the third is what's sometimes called the DPA, or data processing addendum, which is an agreement, essentially, a contract between someone who processes data and who owns data, and to protect that data and to protect the privacy rights that are related to the data. I'm going to say one of the biggest changes that has come across that did come into effect is that the CCPAs now applies to what I call employment information as well as other personal information. But before we get to that, the personal information that is covered by the CCPA is incredibly broad. It's all information relating to an identifiable individual. It can be things as mundane as your particular tastes in music or in clothing, or whether you actually have a history of returning a certain type of clothing. It can be something as important as a social security number or an identifier, but it's potentially, not necessarily in every case, very, very broad. This follows on from the other landmark privacy provision, which is many of you have heard of, called the GDPR, which applies to the European Economic Area, and there's many GDPRs, or not so many GDPRs that apply to that are in Britain post-Brexit, Switzerland, and certain other countries as well. But the CCPA took up from the inspiration of the GDPR to protect a much wider variety of personal information than the prior privacy laws. For years, and I know many on this call, many others are very well familiar with California's pioneering data breach notification law. That applies only to a subset of information. A subset of information compared to the personal information. Things such as social security numbers connected with personal information. But the CCPA, for the first time, put into effect across most types of businesses, not all of them, but across most types of businesses, these protections this protection and the rights that are given to consumers to have information. Now, Jordan mentioned several of these important rights, and I think that three of the most important ones are the right to know, that is, the consumer's right to know what information a business is collecting about the consumer, the right to delete, and the right to correct. There are other rights as well, the right of non-discrimination. There are also rights not to have your information, personal information, sold or shared, and those are very important. But I think the rights to know, the right to delete, and right to correct are very important. And what does this mean for a business? What does it mean for a business subject to the GDPR or a business, excuse me, the CCPA, or a business that receives some sort of request for a consumer? This means that the business has to show consciousness, I think, in terms of what personal information it collects about an individual out there, and it has to provide a response to legitimate inquiries that are made by those consumers. And where is this done? It's done a couple different ways. The first way it's done is that we also have a law in the state of California that says that any business which collects personal information about a consumer has to have a website privacy policy. I am shocked from time to time. I'm called in on deals, corporate deals, mergers and acquisitions. And the first thing that I do, let's say it's a small air conditioning supply company, a plumbing company, big enough to have be a worthy target of a merger or an acquisition, I will find that there are many businesses with online presences that collect information about consumers that do not, to this day, have a privacy policy in place. Of course, the big companies do, and many of the medium-sized companies, but many businesses are unaware that you absolutely must have a privacy policy on your website if you collect personal information about a consumer in the state of California. And what is that personal information? It can be any of those categories that I talked about before. It can be something as simple as having subscribing to a newsletter and collecting information such as email addresses from a consumer. It can be something more complex. It can be a complex form that has to be filled out. It can be a website that has a recruiting contractor. So most every website needs a privacy policy, but there's more. Privacy policies are also needed at the point of collection of all personal information. Now, as of January 1st, 2023, this includes employment information. Most of you know probably that California has some of the strictest and most complex labor and employment laws of any country. I call it a country. We have our own hurricane, so I guess we can be called a country of any state in the United States. And those laws give very robust protections to employees and for collection of information in the workplace. Starting on January 1st, 2023, the exemption which had applied to employment-related information, and I'm not just talking about employees, but I'm talking about recruits as well. The information that's collected about an employer, about recruits, the information that's collected by a recruiter about the recruits, which is passed on to the employees, is subject to the CCPA and is subject to the same main rights that apply to other types of personal information. Just to remind you, in the employment context, that relates to the right to know, the right to delete, and to the right to correct. And so much of this information is not gathered traditionally as we think of on an e-commerce website. We have many e-commerce providers as clients, and they are very well aware of the need to have a privacy policy and to tell those who visit the website what information is being collected by them or what information is being collected by others that they use as contractors. I think mostly of Shopify, which is a very, very common vendor that is used in the e-commerce area. But employers now and recruiters and those who deal in that space also have to have privacy policies. A lot of recruiting information, our recruiting information, for example, for lawyers here, for summer associates, for lateral hires, is done through online third-party vendors. But those third-party vendors and we employing those third-party vendors have to provide notice regarding what information we're collecting and to provide notice of the rights that recruits, not just hires, have. Similarly, with employers and employees, information collected about employees that is personal information under the CCPA has to be disclosed to the employee through a privacy policy. That is not the same privacy policy as goes on a website. It is a simpler privacy policy. It simply talks about what we call a workplace private policy. We decided that was the best term for this more simplified privacy policy about what information is collected by the employer in the workplace, what the purposes are generally for that, and what rights the employee has to find out about that information. And of course, that creates all sorts of interesting situations regarding how employees might use that information, how employees, plaintiffs' lawyers might use that information as well. But keep in mind that in the employment relationship is no longer something that's separate and apart. In California, it's subject to the California Consumer Privacy Act, and employees have to be provided a notice through a privacy policy, and there has to be a respect for the basic rights in California that come with that. So that's one reason that we recommend very strongly that you do not have a privacy policy that combines the employees in with everyone else. We want to have the employment privacy policy and the requests made under it administered quite differently than they are in a regular consumer-facing privacy policy because of the delicate HR information that is there gathered. I know that there were some questions about background checks and background information. A lot of that information, along with kind of information that you take on inputting clients in some place like a law firm, is also considered personal information under the CCPA. It may also be subject to other laws, as I mentioned, I think, when we were in the chat. The biometric privacy law of Illinois is the leading privacy biometrics law in the country, and there is not one quite like it yet. But there's attempts every year, just as Jordan said, in the state privacy laws to have new biometric privacy laws. So there has to be awareness of what the rights are to those who are either employees or job applicants. There was, just as an example, there was a very famous lawsuit brought this year under the BIPA, it's called, the Illinois privacy law, by the employees of Burlington Northern Santa Fe Railroad relating to the scanning of fingerprints as they went into the yards to be employed. There was at a time, I think that this verdict is now, it's now going back to the court for a reassessment of damages, but the verdict I think was something in the range of $240 million against BNSF for not providing notice and regarding the collection of this information, which it did, by the way, through a vendor. Okay. The second thing I want to talk about is the use of vendors. And this, I could get into the technical weeds here, but most companies are either vendors or use vendors, or they can be both. And that has important consequences in California. If you are a company that processes, that handles, manipulates the personal information of your client, then there should be in place protections to the personal information through a data protection addendum or an agreement of some sort. That is required under the California privacy law. We've seen it for years under the GDPR. In fact, we often would get these data protection addendums that were full of the terms of the GDPR. You notice right now that I'm using the term processing, which is a term that's used under the GDPR. You have data controllers, data processors. But if you are handling, or you have a third party handle the personal information, there should be in place contractual protections for that personal information. And coming along with that, those protections of the personal information are the protections of the security of information. Because as Jordan said, security and privacy go absolutely hand in hand here. And that is a second requirement. That's a second, I think, pillar of the kinds of agreements that you need to have in place or consider having in place are these data protection addendums. I wanted to talk a little bit about lawsuits and private rights of action. I make a minor correction to something Jordan said. There is indeed a private right of action under the CCPA, but it's a limited private right of action that only goes to security of information. And it's a narrow definition of personal information. But as far as these rights that I've just been talking about, the rights that consumers have, those are enforced by the new California Data Protection Board, and they were formally enforced by this Attorney General. So there is, I think, a certain amount of frustration in the plaintiff's bar out there in regard to this. We have this wonderful CCPA, it affords all these rights. There are a lot of companies that are not following those rights, and they can't get around that with a direct hit based on the CCPA unless there is a security breach. That's a big if, but it still led to enormous frustration among the plaintiff's bar that would dearly like to have a privacy cause of action that could be stand up there along with the private attorney general world, along with ADA compliance for websites. And lately we've seen some very innovative things that the plaintiff's bar are doing relating to using wiretapping laws to try to make the use of various kinds of cookies and session replay on websites into a form of wiretapping. These lawsuits are hitting many of our best known e-commerce providers. And strangely enough, one of our best known e-commerce providers, which is associated with a celebrity clothing provider, had its users targeted on Instagram and other platforms with ads for the plaintiff's firm saying, has your privacy been violated? Get in contact with XYZ firm. And it all comes down to the kind of session replay cookies that are being used on websites, which are in place to sort of try to optimize the website, analyze the use of the website, but they're being made into a quasi-privacy violation. So that leads me to the kind of third pillar of what I want to talk about, which is not exactly a privacy issue, but is a broader issue in relating to the terms of use, how to protect against these types of opportunistic ploys by plaintiffs' firms that are using statutes that were meant for a completely different purpose. We've even actually seen one under the Video Privacy Act recently that said that the various recordings of recording capabilities of certain websites can fall under the Video Privacy Protection Act. If you think back for trivia, the Video Privacy Protection Act was associated with the revelation of Robert Bork's records for renting videos when he was up before the Supreme Court all those years ago. And Congress got on the ball and protected a right to protect your video records, but of course has not gotten around to actually passing a privacy law generally. So one thing that you can do to try to guard against some of these opportunistic things, and this is the third big pillar of what I want to talk about today, along with privacy policy, the data protection addendum, is to, if applicable, spruce up your terms of use. Spruce up the terms of use so that you can try to restrict the types of lawsuits and the forums for the lawsuits that are brought if there is one of these opportunistic challenges. And in that connection, it should be also, everyone knows about arbitration. Everyone knows about wanting to have arbitration, but it's important with what type of arbitration and the restrictions of arbitration that are put in place. Do not opt blindly for AAA arbitration. That is my sincere recommendation, and you can follow up with me if you have any questions on that. I don't mean to, it's not a political question, I don't think, to talk about AAA, but it's something that's knee-jerk put into terms of use. Be careful what goes into the terms of use, how you're protecting your business or your client's business by those terms of use. And this is not precisely a privacy issue, but is a practical issue to a lot of clients that we see in all different spaces who see that the frustration of the plaintiff's bar in trying to find a way to sue businesses with websites, particularly if they're associated with prominent individuals or are prominent websites, is leading to more and more attacks that are, you would say, are in the quasi-privacy area. So I kind of would like to recap. Just a couple things. We do not have final regulations under the CCPA. This is a work in progress. Other states are definitely getting active, although I don't think that they have displaced CCPA yet, and we have no, I think, realistic prospect of CCPA and other state privacy laws being displaced in the near future. These state privacy laws have broad impact. They have practical impact on the day-to-day basis. And we're called upon for medium-sized businesses to really respect and to try to understand the ways in which those businesses are using data and the ways that they can protect themselves to make themselves less vulnerable. Keep in mind, if you take one takeaway from this today, keep in mind that employment information, recruits, information about contractors in some circumstances is protected now under the CCPA. It calls for a completely different privacy policy, or not totally completely different, but somewhat different privacy policy, and it requires special handling. So those are, I hope, some of the practical things. I know I'm a little under my time, but I wanted to leave some time here for questions. And if there's anything specifically you could, that I mentioned that you want to question me about, you certainly feel free to contact me either here at Toohey@ggfirm.com or through LinkedIn or another means. Thank you.
Thanks, Tim. I appreciate your time today. And everyone, questions and Q&A across the board. The time is now. Why don't you, if you want to, you can type into the chat, and I'm happy to call on you to actually speak if you'd like, or I could say it verbally myself. But I see a question. Let me see if I go back here. Okay, looks like Scott from Duco Expert. Looks like you had a question on here in regards to, and I believe it's probably maybe the delay in federal privacy laws getting maybe getting passed.
Yeah,
the question,
it was just that we don't have anything on the federal level. You said it's a patchwork of state stuff, and certain verticals there's federal stuff, and I'm curious, why is it so challenging to get this done at a federal level? Is it a feature or a bug? Just curious.
Why is it so challenging to do anything at the federal level? But
kind of what I was expecting, but I mean, who knows? There might be strategic reasons for it to allow for innovation and experiments.
Well, yes, it's the traditional dichotomy would have been, and I think back to the broadband rules that the FCC wanted to pass a few years ago. Where you had new administration that came in, you had a new head of the FCC, they disapproved the broadband rules, and the mantra then was innovation, bureaucratic overreach. Some people don't want the FTC to have more power. And then the big fight is whether those laws should preempt state laws. And you can imagine the California delegation, I was about ready to say rightly in my view, but that's perhaps a partisan California statement. The California delegation does not want to give up what they've accomplished in CCPA. And some people would like them to give it up, some people would not. So preemption of state laws is a problem. And then, of course, the private right of action is a real bugaboo. There's limited in California, but there's still something there. This is a big controversy in Congress. So it should be nonpartisan to protect privacy, but the devil's in the details. I don't know if Jordan would agree.
No, I definitely agree. And in fact, would just say the closest we got, and I don't mean to imply we got close. The closest we got with the federal law was last year, and it was the California delegation that ended up being the reason why it couldn't get passed. So I think states are very aware that they're putting all this effort into addressing privacy. They have their nuances based on sort of the industries that they have, the different stakeholders, the interest groups. And California is a great example. They're unwilling to sort of risk potentially having a federal law preempt and potentially sort of water down the protections that they've created. So I will say, I think, unlike about 5 or 10 years ago, where I think industry members had zero appetite for a federal law, as we get more state laws, that approach has switched, right? And the industry is now, I think, much more willing to come to the table to have this conversation. But now you have these states that have their own laws, or you would have had that 5 or 10 years ago if we were having this conversation. So I don't, candidly, as we head into, election cycle, I don't think we're necessarily going to see any. This is a very contentious issue. There's a lot of stakeholders involved. I don't think we're going to see anything, at least for 2+ years.
Mm-hmm. Great answers. Does that answer your question, Scott?
Yeah, sure does.
Okay,
so,
great.
I mean, ideally, there would be something there for the sanity of these workers. It sounds like it's difference in culture across or beliefs across our great nation that has not yet led to something that can be passed federally. If I heard that correctly, then yeah, I think that's super interesting.
I would think that there would at least be a national data breach notification law, but there is no such thing.
Interesting.
And so you have to, if you're ever unlucky enough to have to provide data breach notifications, it's become a little mini industry, of what each state wants, and each state has a different standard who you have to send it to. It's a nightmare. I like to pass it on to others in my organization to do those, or to a third party, but we don't even have that.
All right, so I've got to follow up now, because with this patchwork of things and how complicated it can be, like I said, we work in the space, but on the policy side with companies. And when there are smaller companies, they want to set up good hygiene. They want a good foundation. They want best practices. But dealing with these complicated issues is a very expensive proposition. And we've sort of struggled to find a way to work with these earlier stage companies as a viable business plan. And, what sorts of advice do you typically give to a group like that? Is it to seek out like a Schmidt Futures nonprofit and see if they have some best practices that you can download, or I don't know, what do you guys see being done at the earlier stages to help move these companies along when they can't really afford or put the resources into something as complex as this?
Yeah, it's a great question. The European laws don't carve out small businesses per se. There's a little bit there. The US tends to be carving out or attempting to carve out some smaller businesses, right? Like you have revenue trigger in California, 25 million. You have sort of amounts of data. So if it's really de minimis that you're collecting data in a state like, Virginia, right? You're not going to have to comply with that law. So I think that doesn't really answer your question of how do we put best practices in place. That sort of answers your question. Do we have to do it? Right. Which for giving giving startups some, time to play and innovate. I think there was a intent behind there by creating those sort of higher level triggers. I always like when I'm dealing with smaller businesses, and we work with startups all the way to multinational companies, right? So I've got $1,000, I've got millions of dollars, right? Depending on where you sit on that. I always like to point to resources like NIST, the National Institute of Standards and Technology. I think the CSF and the privacy framework are both good starting points. They don't read like a controls-based framework, so it'll be a little bit easier to understand if you're not used to this space. I think it's a little bit more approachable. I'm trying to imply you can pick it up and do it yourself. I do think this space just requires some level of knowledge in it. But I think those are some great starting points. And they use a lot of sort of principles that you can understand, right? Risk, governance, management, et cetera. But oftentimes when I'm working with smaller businesses and even larger businesses, you have to take a risk-based approach. Nobody has an unlimited budget in this space. You're lucky if they have a specific budget for privacy in the United States. In Europe, it's a very different conversation, right? When I'm working with European clients, this is a very different approach that's being taken.
They're ready.
Yeah, exactly. Well, it's been around, right? They have a fundamental right to privacy. They kind of have an agreed upon cultural component to this, but we don't even have in the United States. And so, you take a risk-based approach, which is outward facing disclosures, things that are kind of sort of demonstrate to the world that you're doing some of this, and then you sort of turn inward. Rome wasn't built in a day. You're not going to do this in a day, but putting in place a plan, and whether that plan takes 10 years or 2 years, right? Obviously, from a risk-based approach, you want to do it sooner rather than later. But I think, so often people feel like we're opening Pandora's box and we have no idea what we're going to find when we get in there. Closing your head to it is not great, because then if you have a breach or if a regulator comes in, that's the worst time to find out about it. But sort of methodically making progress and maturing and just understanding your business from a privacy perspective, there's wins in that, even if they're not these like massive wins that you can sort of say we've addressed everything under the sun. So I don't know if that helps, but I would say NIST, not the 800 series, but looking at CSF or the privacy framework are some good baselines to sort of start using. They're free, they're online, right? They're published by the US government. So there's some credibility in sort of leveraging that as a baseline.
That's a great pointer. Thank you. I haven't checked those out, and I will have to do that. And then just one other interesting thing, because you mentioned the US sort of has size gating. I think in the new DSA laws that are coming into effect now, Europe's got some interesting distinctions for like very large online platforms versus all these other ones. It's good to see they're cutting a little more slack to the startups over there. It's good.
I would only add that it really depends on what business that a company is in, because we have some online innovative businesses with apps connected to websites collecting certain information, and they have to build it right from the start, or they're not going to.
Great. Next question I have coming up here from Roger. Are there services arising which enable companies to keep current and compliant with the various privacy regulations, including notifications to customers, perhaps HR consulting firms, or even legal firms with that capability? This seems like a great opportunity for consulting firms with the right skills.
That's why there's hundreds of them. From the big, however many accounting firms, to the literally dozens of companies that you see at privacy organizations, conventions like the AITP. There are plenty of them out there. And there's most law firms will tell you they can help in this as well, but you have to be careful who you choose. The price, there's a lot of this can be expensive, and you really need to know who to call. I think that law firms may be in a position to try to help you separate some of the wheat from the chaff here, because they deal with some of these firms. But there are literally, dozens, if not, I would say hundreds of firms that are out there that are trying to make money out of privacy and this whole complexity that we're talking about.
Yeah, I'll just add, I threw in the chat, our firm puts out a data privacy map, for what it's worth. We update it. We're continually updating it because it changes so often. A lot of firms do this. So there's I'm just throwing the one that I know of, but there's other firms as well. And we have an annual reference book that we put out. Candidly, the challenge in this space, even if you go to sort of like the LexisNexis and the Westlaw, which are sort of these legal research areas, it changes so quickly. That's a good starting point to look at some of these sort of free resources, but you've got to go to the source and sort of make sure that it's still relevant, because you could put something in there today and it can evolve rather quickly. So that's the challenge I see in this space, but that's one resource if you're looking just for like a quick hit. And, candidly, we're updating it regularly just because it's challenging to keep up to date. So.
Go for Roger.
Yeah, there would seem to be a good reason to rely on a third-party firm that is keeping current, so they can help your firm keep current. Okay, thank you very much.
Let's see, another topic that I got brought up. Let's say, I guess it's regards to accepting cookies when you get onto websites. It looks like many websites don't allow access to the website unless you accept the cookies. But if you opt out on a computer, will it carry over to any mobile devices that you use?
I don't think so.
I think you're asking a bit much from people who are dealing with cookie banners.
Yeah.
Yeah, I mean, cookie
absolutely.
banners are strange enough not a requirement that has been imposed by U.S. privacy law by and large, but is a holdover from the GDPR. And now we have a do not sell your personal information. Soon we're not going to be able to see our websites. But cookies and all of this stuff is still important, as I said, because it's being exploited by these firms that are trying to find a way around the lack of private right of action. So you have to pay attention to what you do, how you're collecting the information, who you're sharing it with. If you're involved in the advertising ecosystem of targeted advertising, which is very common. That's where you really have to be very careful about all of that and make sure that your privacy policy is buttoned down and that you're doing what you said you're doing, and no funny business there, because I think that's where the new California Data Privacy Board is going to be very active, and we see the Europeans are already hot on this area. So it's going to continue to be. So cookies are important, but the cookie banners are an annoyance, but in my mind it was.
Well, it looks like we're up against the end of our time here. And before I display our slide with upcoming events and you guys can fill out the survey, are there any final comments from either you, Jordan, or Tim?
No, I'll throw my contact information in the chat. Feel free to reach out, connect on LinkedIn. I know that this area is changing quite rapidly. I'm always happy to be a resource, whether that's pointing to free resources or wherever I can. But really appreciate everyone tonight. Privacy is fun. It's not daunting. So I think it's a really interesting space, and always happy to talk about it.
Thank you, Jordan. Tim?
Yeah, I was going to do the same. If I can figure out, I'm having it's Toohey@ggfirm.com. Anyway, I'm stuck in don't have the right chat thing up here, but thanks for everyone's attention. If you're local in California, I hope to see you at some sort of a gathering at some place in the near future. And otherwise, feel free to contact me.
Well, thank you guys so much for jumping on and speaking for our group. The rest of you folks, feel free to take down that contact information. Tim, I'll find it and put it on here, but I'm going to throw up the upcoming events.
I just had the wrong thing up here. I had a private chat. So if you could just put it in there. Thanks. Bye-bye.
You got it. All right, guys. Here's the upcoming events. We have coming up on September 13th, right around the corner. We're partnering with AppSec for their SoCal conference. It's over at the Annenberg in Santa Monica. Let's see. Let me just do this. If I can select it. Oh, no. All right. Let me put this information in the. Let me see if I can put this into the chat for us. Okay. Beautiful. September 28th, 2023. This will be, sorry, the conference is in person, so that's over there. And then September 28th, end of this coming month, will be a virtual event. Peter Coffey does his annual forecast. We'll hear from him. He's done a fantastic event each year, and he talks about the latest developments of technology. And you can hopefully get a good glimpse into what we're looking forward to in the future. Later in October, it'll be an in-person event, a CTO Insights panel. We'll be bringing together a bunch of different CTOs. It'll be moderated by Dr. Tony Kerr, and hopefully we'll be able to have you guys out there. And then in November, we've got another virtual event, and this will be a panel of cybersecurity experts, moderated by Dr. Stan Stahl, discussing cybersecurity protection strategies. So I hope we can have you guys there. In the meantime, here is the QR code, or let me see this link. Why can't I click on it? Let me see if I can put these things up for you and make it easy for you guys to click. There we go. There we go. And you can just check on the chat. All right, it's not as easy as I thought it was going to be. There we go. Perfect. Okay, that is the link for our post-event survey. So make sure to fill that out.
Great.
Following that is going to be our link to the conference. If you're interested in attending, we do have a discount code. I'm going to put that in here. Make it easier. And last but not least, Tim, let me see if I can add in your email. Oh, you got it in there. Perfect. All right, fantastic.
All right.
Thank you guys for attending, and we look forward to having you at the next one. I'll leave this up for a few minutes until everyone's dropped off. Thank you.
Great job, Jay. Great job, Nilu. Thank you. Thank you.
So we've got several in-person meetings coming up soon, so they'll give us an opportunity to network. Thanks everyone for attending.